Thank you very much. First of all, I would like to thank the organizers to invite me for this very special and grateful conference. And today I would like to show you the national perspective towards licensing framework in the Slovak Republic. As you pretty well know, I guess that most of you, that the licensing process is very, very complex. My presentation is also going to be reflected as quite long, but I will try to be reduced and will skip some slides because of the time constraints. But before I move forward, I would like to say that as was already touched upon, that the vendors and mostly financial institutions and financiers are very much concerned with building new nuclear installations, not only nuclear power plants, but mainly nuclear power plants, because of the financial capacities that are very huge and are predominantly dependent on the licensing framework. Therefore, nowadays, technology is going forward. Technological innovators has come with SMR, small modular reactors, microreactors, AMRs, and many other technologies that should, they think that the licensing process with these kind of technologies will be quite reused and shrank, and that the financial institutions will be able to provide so necessary finances. It's a big question what will happen later on in the European Union, especially also with the climate goals, but the problem is that without nuclear we cannot go forward because the supply energy demand will be higher and higher, and meeting climate goals until 2050 without nuclear energy is, from my point of view, impossible. So today I would like to introduce the legal framework in the Slovak Republic, then environmental impact assessment, licensing process as such without environmental impact assessment, which is a part, but regarding only the nuclear technological side, and then I will sum up. So legal framework. In Slovakia, Slovak Republic is party to many international agreements. As you can see, there are some of them, but is party to most of the international agreements, such as Convention on Nuclear Safety, JC, Joint Convention, Treaty on Non-Proliferation of Nuclear Weapons, environmental agreements such as ESPO and Aarhus Convention, and many, many others. Then we also, as a member of the European Union, we are also party to the establishing treaties of European Union and Euratom, plus as a member of EU, we also comply with directives and regulations. From the national point of view, we adopted a lot of acts. The basic act is the Atomic Act, for which is responsible in the Slovak Republic the Nuclear Regulatory Authority of the Slovak Republic. Yeah, let's go on. The Nuclear Regulatory Authority adopts also so-called sub-legal acts, which are decrees, and these decrees are necessary to follow in the licensing process. So environmental impact assessment, which is very important to mention here, is that the environment, or so EIA, we call in Slovakia EIA process, is divided into mainly two parts, which is strategic environmental assessment and environmental impact assessment, such as. And those two are different. You can see the differences which applies in Slovak Republic are in scope, purpose, content, procedure, an outcome, which is the final document. In SEA we have, or in EA we have final opinion, and in SEA we have so-called final statement. This is the legal and national framework which applies to the strategic environmental assessment. So I start with SEA. What is important to mention is what really SEA is basically a tool for the assessment of the likely impact of strategic papers during their development and before adoption thereof on the environment, including impacts on human health. Whereas environmental impact assessment is focused not only on strategic documents, but also focuses mainly on activities. The strategic environmental assessment procedure includes the submission of a communication on the strategic document, the scope of evaluation of the strategic document, the environmental impact assessment report. So you can see that the EIA is part of the strategic environmental assessment, and the final opinion on the assessment of the strategy paper. The SEA includes several essential steps, such as submitting a notice, screening procedure, scope of assessment and time schedule, environmental impact statement, commenting on assessment of an environmental impact statement and public hearing, expert review, final review, and close of impacts. There are many stakeholders that are involved in a strategic environmental assessment. Here is a list of concerned stakeholders. Yeah. What is important to mention also is that the strategic environmental assessment apply to several areas, and as you can see, energy, including nuclear energy, is part of that. Also in Slovakia, since we are a member of the European Union, and the European Union very much pushes on transparency, or principle of transparency. In Slovakia, principle of transparency is applied to the wide extent possible. So the public is also part of the strategic environmental impact environmental assessment. They have several rights. You can see, for example, right to submit a written opinion, right to participate in consultations and public discussions. The competent authority in SCA in Slovakia is Ministry of Environment, then the district office in the seat of the region. We have 8, let's call main cities, and in each city we have district office. Therefore, it is called district office in the seat of region. And we have another district offices which are in other cities in Slovakia. And also the Ministry of Environment is, of course, the approving authority, and also those two. And the final statement is the outcome of the strategic environmental assessment. Here you can see what the final statement includes, which is the environmental impact assessment of the strategic document, whether the approval authority recommends its adoption or not, under what conditions, and the required scope of its monitoring and evaluation. On the other hand, environmental impact assessment is the process of environmental impact assessment of strategic documents prior to their approval, then also regards activities prior to their location or to their permission under special regulations, environmental impact assessment of strategic documents and proposed activities in transboundary context, and it also deals with the competence of state administration. The procedure, the environmental impact assessment procedure, is governed mainly by the Act on EIA, and then from the procedural point of view, by so-called administrative code. It has several steps, those 6: plan of a proposed activity, extent of a proposed activity, report on assessment of the effects, commenting on assessment, expert opinion, and finally the final opinion as the outcome. So now you can see those differences between SEA and EA. What is also, I would say, very important to mention is that the final opinion is binding for further procedural steps in the entire licensing process and is valid for 7 years from the date of its entry into force. All the details regarding the final opinion you can find in the Act on EA, especially in Annex number 12. Also, there are multiple stakeholders, such as proponent, competent authority, departmental authority, permitting licensing authority, affected municipality, public, concerned public, NGOs, and party of origin and affected party, which are mostly involved in a transboundary context. Also, public participation, as was in SEA mentioned, the same procedure applies in public participation in EA. They have several rights. And also, principle of transparency, all the documents that are part or that are included in the EA procedure are of course published on the website of the competent authority. And now I would like to go forward with the core licensing process. The licensing process, as I mentioned, is very complex and consists of several stages. And those stages are siting, construction, commissioning, operation, and decommissioning. And those phases have to continuously follow each other. So in basic terms, licensing process is the procedure that entails reviewing and assessing whether the applicant, which is a future licensee, complies with all applicable legal requirements. We are speaking about safety, security, safeguards, environment, and so on. Basically, in the nuclear sphere, those are called as 4S or 3S plus. There should also be mentioned liability, which is those plus. License. Basically, license is the legal basis for the operation of an NPP. The absence of a license may trigger penal sanctions. So it means that when we saw those steps or phases signed in commissioning, construction, operation, decommissioning, they cannot be started without the permission or authorization. Elements of a license are basically the identification data of an applicant, which is a future licensee, definition of subject and scope of a permission, determination of conditions of a permission, and determination of time limits of technical restrictions of an issued permission. This is of a big concern because, as you pretty well know, not only in the European Union but also in the US and other regions, there are time shifts and the projects are not completed according to the plan. So the time limits are, as a standard, shifted on. Conditions are basically the general conditions and special conditions. The special conditions apply to siting phase, commissioning phase, and trial operation. Main stakeholders are applicants and licensing authority, which is in the Slovak Republic the Nuclear Regulatory Authority. And UJDSR grants a license upon completion of the requirements, defines conditions and prerequisites required for the license issuance, and performs supervision or so-called inspections. These entities are the main entities that are involved in the licensing process. So the core one is UJDSR, Nuclear Regulatory Authority, and the others such as Ministry of Health, Ministry of Labor, Ministry of Interior, Ministry of Environment are also involved. Ministry of Health There are even other sub-entities under those ministries, such as Radiation Authority, which is very, very important in this sphere, but it is in the structure under the Ministry of Health. Nuclear Regulatory Authority is the central administration body, such as the ministries, so they are on the same level. So there is only one body that is under the ministries and the nuclear regulatory body, that is the government. These are the main phases. I will come to them later on, but this is the main phase of the commissioning process, so it's just a part of the licensing process. But as I told you, I will come to that later on. The basic legal document is the Atomic Act, which deals with all the licensing phases and provides the basic regulation. The another very important act is the Construction Act, because the nuclear regulatory body is not only responsible for nuclear safety. If I speak about nuclear safety, I mean all 3S+, security, safeguards, and liability. It's all nuclear security in principle. And the nuclear regulatory body is also responsible for construction, so it's a construction authority, but you will see it later on. As I mentioned, UJDSR issues administrative decision for each licensing step in the form of either consent or approval, or permit or authorization. So there are differences, but small. Speaking now about citing, so now I would like to shift towards the concrete phases. Citing, the legal requirements for the applicant are enshrined in the Atomic Act. Everything starts with the submission of an application. There is a big change since 2021 by adopting a new law, amending the Atomic Law, which have come with a new Article 17A, which in principle means that nuclear regulatory body until 2021 was not the competent authority in the citing phase. It was the municipality, and in this process, the nuclear regulatory body had only recommendatory vote or power. But after adopting this law, coming with new Article 17A, a nuclear regulatory body is responsible and competent authority for citing, but only if it comes to the regulatory reactor buildings. I'm sorry to say, only to the reactor buildings. Yeah, here you can see generally in citing and in construction phases, the competent authority is municipality, and particularly if we are speaking about citing and reactor buildings, it is nuclear regulatory body, UJDSR, and for construction it is only for all the nuclear installations, it is UJDSR, the regulator. Speaking about construction phase, there are two phases, phase of the project and phase of the construction. Speaking about the project, it's mainly dealing with the documentation, and speaking about construction, it's only about the real construction on site. The basic legal requirements are in Atomic Act, Construction Act, and those two decrease on details on the nuclear safety requirements for nuclear facilities, and on details concerning the scope, content, and method of preparation of nuclear installation documentation. Also, construction is possible only after receiving the construction permit. And now commissioning. The basic document that regulates the commissioning is a decree on details on nuclear safety requirements for nuclear facilities. And the commissioning is divided into two main phases. It's physical commissioning and power, or some say energetic commissioning. And now I would like to show you again this scheme. So we have physical startup and energetic startup, power commission, let's call physical and power, and we have several substages. For example, in energetic startup there are even 11 substages, and you can go from physical startup to energetic startup based on the authorization. But if you want to go from, for example, from fuel loading to physical tests, because the commissioning starts with putting the fuel pellet into the reactor, right? And this is called fuel loading. And if you want to go on, you have to shift from fuel loading to physical tests. And for this shift, you don't need to have an authorization. You need to have kind of special permit, but it is the outcome from the inspections. So there is the inspection as a procedure, and the outcome of the procedure of the inspection, which is the protocol, gives permission going on to another subphase. All right. Now speaking about the operation. Operation is also divided into two subphases, which is the trial operation and normal operation. So in principle, operation starts with the trial operation. It is the permission for the trial operation is basically based on the so-called 144 hours operation of the reactor. After it completes these 144 hours operation, it demonstrates, the reactor demonstrates that it's fully alive, and then the regulatory body, based on the tests and results from this trial run, can adopt the permission authorization for trial operation, which is now the case with our fifth unit, Miskolc nuclear power plant unit number 4, which is now still in the trial operation and waits for normal operation. There is still no decision for the normal operation issued. What is very important to say is the communication, because at least in in Europe, in Slovak Republic, we are a country that is a neighboring country with Austria. Austria is very anti-nuclear. They have their own NGOs, such as now very active Global 2000. Greenpeace, I don't know whether they sleep or something, but anyway, Global 2000 is very active, and they were very much pushing on the regulatory body, and there were even so-called whistleblowers that were sending a lot of documents and evidence to the Global 2000 based on various reasons, mostly individual reasons, but I do not want to come into those details. So the communication is very important. The nuclear regulatory body communicates all the steps, even the decisions are, and all the materials regarding the commissioning process and construction siting are published on the regulatory body's website. Even the draft of the decision that should be issued is published. The public may comment on the draft decision. Based on that, on those comments, the regulatory body will decide whether we'll issue the decision, the final decision, or not. And this was the case with the first. So we have first instance decision according to the administrative code, and the second instance decision. I wouldn't like to touch upon all the core parts of the decisions, because you are very well aware as lawyers what is the structure of the decision. We have appeal procedure. Nuclear regulatory body is responsible not only for the first instance but also for the second instance. And who is responsible concretely is the chairperson of the regulatory body, who decides in the second instance based on the recommendation from the specific committee. You can see, shall decide on the basis of a proposal submitted by the special appeal committee. After the second instance decision is the final one, speaking about the administrative process, and if the concerned stakeholders are still concerned, they may lodge the action into the court. So there is a judicial review, which is basically 2 instances. The third instance is a special remedy, extraordinary remedy, and the final, absolutely the final remedy is the constitutional court with a constitutional claim. Yeah, to sum up, the basic documents are the Atomic Act, and as regards the environmental procedure, it's the Act on EIA. Slovakia very much counts with principle of transparency. There is a wide participation of several stakeholders. Slovakia is party to robust scope of international agreements and legally binding documents, and even non-legally binding documents, speaking about the IAEA umbrella. Basically the safety and security guides and standards. There are many governmental bodies involved in the licensing process. Licensing process is very technical, and as I mentioned, there are several instances in the administrative and court legal procedure. So thank you very much for your attention.